all across America and around the world. This is Veterans Radio. This is Veterans Radio.
Welcome to Veterans Radio. I am Jim Fausone. I'm the officer of the deck today. We've got some great programs for you. I think you'll find very interesting. We always want to remind you can find more about Veterans Radio at its Facebook site or at the web. Veteransradio.org is our new URL, veteransradio.org, where we're on the web 24/7. You can find a lot of our podcasts there as well. We post new ones every Tuesday, so you can get a new story, a new interview, something you didn't know before by going to veteransradio.org. And before we get started, we want to thank our sponsors. First up, we want to thank National Veteran Business Development Council, nvbdc.org. It was established to certify both service-disabled and veteran-owned businesses. You'll find out how they can help your business by going to nvbdc.org. We want to thank Legal Help for Veterans. Legal Help for Veterans fights for veterans' disability rights all across the nation. You can reach them at 800-693-4800 or on the web at legalhelpforveterans.com. We want to welcome to Veterans Radio today Dwight Stirling. Dwight is a retired major. We're going to talk about his background a little bit, but he's an expert. He has a doctorate in something called the Feres Doctrine that he did his thesis on. Don't worry, folks, this isn't too complicated, and it's trying to address a real issue. Dwight, welcome to Veterans Radio.
Yeah, thank you, Jim. Thank you.
Well, you spent 21 years in service as an active duty JAG officer. You were also deployed overseas as part of a NATO thing. Tell us a little bit about your background.
I joined late in life, Jim, as a 32-year-old. I was working at a big law firm in Los Angeles, and then a 9/11 happened. And that, like a lot of us, it really turned my world upside down. And so within a couple months, I had, quit my civilian job and was back at Fort Jackson, South Carolina for my boot camp. And then I did that and became an officer, went into the infantry for a while. And then I realized that it's where my real skill set is as a lawyer. And so I switched to being a JAG.
And you had time both active duty and, as I say, with the California National Guard.
Yes. I was, active with the Guard for about 12 years, and then went back into reserve type of a status at the end of my time.
You hold your bachelor's degree from Sonoma College, your doctorate, Juris Doctorate or law degree from USC, and a doctorate in education from Pepperdine University. So
yes,
you're a schooled. You've done all this great schooling, and that's what we're going to kind of talk about, applying it to something that is sounds esoteric. It's the Feres Doctrine. Can you tell us what that's about for the military family?
Yeah, it does sound esoteric, but it's not. And when it gets down to it, it's really quite simple. It's a judicial rule that says that if you serve in the military, it's where you can't sue for any harm that you incur, that you sustain. So while you're a part of the military, so if you're hurt, be it through the negligence of a doctor, or be it through a training accident, or be it through even something like a sexual assault, it's where the rule is that you cannot bring a lawsuit against the wrongdoer. So whereas if any of that harm that I just had described, if that took place in the civilian world, of course, it's where you could sue and have your day in court and hold the person, to account in a court of law. But the Feres Doctrine, says in a nutshell that the rule of civil liability doesn't apply to folks who serve in the military.
So this is a United States Supreme Court decision from 1950, and it arises out of a individual who died in a fire at a New York military barracks, and his wife tried to sue the Army for her husband's death in the fire, and the result is this really broad sweeping doctrine that's been applied for 70 years now or something, that
That's right.
military members, no matter what the injury, not necessarily on the battlefield, but injuries, you trip and fall in the office at the barracks, you don't get to sue anybody.
No, that's right. And that's right. It does stem from that case back in the late part of the 40s. That's when the fire happened up in upstate New York. And it was a terrible accident. It was a faulty heater at the barracks at Fort. It's the forts up in upstate New York. It slips my mind. And what happened is, through this so contractor error with the installation of this heater, in the middle of the night, the barracks it just catches on fire, and there are flames, and it's a group of officers, of young officers, so many of which had served on D-Day in the Second World War. This is like 1948. And almost all of them, were killed in this fire in a very kind of tragic and gruesome manner. So I've talked to some of the families of the relatives of some of the officers who've passed, and the devastation that did with the death of their dads or their grandfathers is just untold. And it really kind of broke my heart to talk to these folks. But so as a result, yes, it's like what you said. It's where the wives and the survivors brought a lawsuit against the Army under the Federal Tort Claims Act. And the Supreme Court, here at the lower level courts, that's where the courts all ruled in favor of the families, and the suits were allowed to go forward. But then the military brought the appeal up to the Supreme Court, and they took the case, and they came down with this doctrine that said, whereas if a civilian is hurt, due to the mistake of, by a military member, a service member, if they're hurt by a colleague as a result of the error of a colleague, it's where they can't get their day in court. It's where they can't file a civil suit. And that happened in 1950, and it's the Feres case, and that is now the Feres Doctrine. And now 73 years later, it's still it's still good law.
Well, it's one of those things where you go, wait a minute, I gave up my right to sue for negligence, for simple wrongdoing. And indeed, that's what the doctrine holds. Now, doctor, play law professor here. This is a United States Supreme Court case, so does every court have to follow this?
Yes, it does. That's how our system of law works. If the Supreme Court issues a ruling, it applies to every person in every state in the country, and so it becomes what's called as a binding precedent. And it's what's known as a case law, because it's made by a case, by a judge, or judge-made law. And yes, and it has been expanded to every nook and cranny of kind of wrongdoing or harm that happens in the military. If you're on an MWR trip, on a rafting trip, and due to an error of the rafting guides, or a problem with your raft, it's where we've had so many folks who have died on these trips, and their families have sued. And it's where the court applied the doctrine there. If you're in the commissary, if you get bad food and you get sick, if like right now, if the water at your base is contaminated, it's where that applies, and you can't sue, because it's where Jim, it's where the theory is that it's where this harm is deemed by the court to be an incident to service, and that basically means that it happened in the line of duty. And the court has said, it's what these lower courts have applied this as a precedent to each one of these cases, and said that service members, if they're harmed by a fellow service member, it's where they can't have their day in court.
Well, this is the sort of thing that drives regular people a little crazy because it, as you say, it's sort of creeped out like weeds to every crook and
It
nanny.
has.
And you've been following this and been scholarly on this for a long time, and you are the founder of the Center for Law and Military Policy. And one of the things that, sometimes bad facts make bad law, sometimes good facts make better law. Are the courts now taking this issue up in the context of sexual harassment claims or negligence claims, and saying maybe there's a little exception, or maybe there's some things around the edges we can do here? What's the current status of this?
Yeah, and I'll just say this at the top as I answer what you've asked here, Jim, and that is that civil liability is really the only way to hold people to account. When there's a mistake made, be it on the freeway with bad driver, be it with a mistake where your employer takes retaliation against you, where and say you're the whistleblower and you're fired. It's a wrongful termination. It's where the ability to file a civil claim and to bring and really to speak as a truth to power is the way that our government and our Constitution has kind of envisioned kind of the little guy being able to have his day and to hold accountability to those who are in charge. And that's how our system is built. And so you asked, are there chinks in the armor of the Feres Doctrine? And by the way, I'll just go on record as I have in front of Congress and in my scholarship. I am a big a critic of the Feres Doctrine. I mean, I will, it's where I'll tell you what it is, but at the same time, I think it's the worst, law that has been on our books for years. The kind of damage it's done to lives of service members, it's where it can't be put into words. And so I want to see it, kind of a ripped, hook, line, and sinker out of our legal system and thrown into the trash heap. And so, yes, it's where there have been some, it's where there have been some chinks in the armor of the Feres Doctrine, and in particular, in the realm or in the scope of sexual assault. And as we know, it's been a big problem, even up to the level of like an epidemic, where female service members, by and large, have been assaulted by their colleagues, and oftentimes it's a member who will rape or assault a junior member. I've done a lot of work in this area, and yes, up until now, it's where if and when the victim brings a civil suit against the perpetrator, it's where the court, that judge of that courtroom will look at the Feres Doctrine and will say, look, so as the victim were hurt by a service member, and the Supreme Court has said that that is an incident to your service, and therefore the court will dismiss that case and throw it out of court, and the victim will not be allowed to suppress that case. And the defendant, which is the wrongdoer here, which is the rapist, it just gets off scot-free in terms of civil liability. And as you know, with the application of the UCMJ, it's where there can always be a court-martial against the perpetrator. But I'm sure you are well aware, as is the audience, that it's where the application of the UCMJ to people in power, like your colonels or your sergeants, or your sergeants major. It's where the application there is very uneven. It's where it's easy to go after the privates, but it's where the system is not inclined to go after those at the top of the food chain. And so often it's where there'll be no civil liability. That's what which is a result of the Feres Doctrine. And then the chain of command, it's where they won't go after the perpetrator either.
Well,
so the result, it's where there's no liability at all. Jim.
And this is, I want to bring this back down to something simple for the audience to think about. The doctrine was set up that if you get harmed in the service of the military as part of your military service, there's no civil liability under the Feres Doctrine. But when we're talking about sexual harassment and sexual assault, and the Ninth Circuit recently used this kind of language, it's clear the act of alleged sexual assault was not incident to military service. Nobody can say the colonel, the sergeant, whoever, the private on private, that's sexual assault is part of military service. So do you think the courts can carve out an exception to the Feres Doctrine, and does it ultimately have to get up to the Supreme Court to carve that out? How's that going to play out? And I wanted to mention earlier, Congress could do something and they haven't. But right. Answer that question on the carve out.
I will. And like you've said here, it's where the Ninth Circuit last year, had a sexual assault case of this type. It was as a service member, as an on-service member. And the victim, brought a civil case out here in California, and the district court, and so that's the trial court, kind of ruled in her favor and said that the Feres Doctrine, that it did not apply, and then it went up on appeal. It's where the military then, it's where they filed the appeal, and the Ninth Circuit said, just like you said here, Jim, that the act of a sexual assault is not, incident to service. That is a crime. It's a, it's awful. It's a tragedy. It's it's reckless behavior. That's a horrible behavior. And the court said that the act of a sexual assault is not a part, obviously, of the military duty of the victim. And that therefore they didn't apply the Feres Doctrine, and that means they did not throw out that case, and they let it go forward, and that's resulted in a carve out. So here in the West Coast in California, that's where I live, and all the Western states, it's where presently, that is, it's where that is. So our precedent. So a service member that lives within the realm of these Western states, these 13 Western states, if they're sexually assaulted by a colleague, it's where they can sue now. It's where Feres, it's where it's been deemed to not apply. And so what I would expect is that, eventually, where that kind of case will go up and be in front of the Supreme Court.
Yeah, I would expect every other circuit, and particularly in the Southern circuits, federal circuit courts, where there are a lot of military bases and a lot of this kind of sexual harassment and discrimination occurs, you're going to see more of these cases. And sooner or later, there'll be some conflicts, and that's the sort of thing that the Supreme Court tries to sort out or iron out.
Right. And so, Jim, at present, there's a conflict of law between the various circuits. It's where, every circuit except for the Ninth has ruled, it's where they ruled the other way. It's where they've sided with the defendant or with the perpetrator, and said that Feres does bar a suit in the context of a sexual assault. And so it's for now the Ninth Circuit. It's where we're the outlier now, and when there's a conflict of law within the circuits, it's where that is where the Supreme Court gets involved.
Well, I think that actually this is good news for service members that. Particularly in those kind of situations where the egregious act has nothing to do with the service duties, nothing to do with government service, or another way to say it is totally unrelated to a service member's military duties. Maybe Jim, you have a way to go forward.
Jump in there, Jim, if I could jump in, just think of the message that the other circuits are sending to our service members. It's where they're saying that the act of being sexually assaulted is part and parcel of your job in the military. It's where that's what they're saying in so many words, and one has to question just kind of the morality of those judges. How do you as a judge, say through your decision that being assaulted is a part of the military duty of a service member? I mean, it's kind of
unsupportable
think
position.
About that.
Yeah, unsupportable position.
Yeah, it is beyond the pale.
So we're beating up on the court here, and probably rightfully so. Hopefully the California Bar Association won't come calling to you, Dr. Stirling. But there's another way to fix this problem, isn't there, in Washington?
Well, yeah. I mean, and heck, it's where the California Bar is on my side on this. It's where it's clear that Feres is a doctrine that has gone amiss. It's way past its expiration date. It's way past kind of the scope that it was for. It's been applied, as you say. It has grown like a weed to areas that it had no business being applied to, and so the Cal Bar is well aware of that, and they won't be upset with me. It's where they'll it's where they'll be on my side on this issue.
Understood.
But yes, it's where. It's where there are two ways to change case law or judge-made law. So one way is having the court decision by either the same court or a higher court to rule the other way. And so here is where the Supreme Court could rule the other way and say that either there's a carve out for sexual assault or for medical malpractice or whatever, and make another kind of carve out there. But it's where there's also a Congress, right? It's where Congress could simply pass a statute that says that if you are injured or if you were sexually assaulted and you serve in the military, by a service member, that you have standing to bring a civil lawsuit. It could be as easy as that one a sentence, and then it would give the standing to all survivors to get to court and sue.
Now, I believe you've testified in front of Congress.
I did.
That seems like a simple, rational, easy solution to this problem. Why hasn't it been implemented?
Well, here, Jim, I've learned the power of the Pentagon lobby. What happens here is that it's where the Pentagon, at the highest level of our military, at the very senior level, they love the Feres Doctrine. And so why do they love it? Because it protects them from civil liability from top to bottom. It both protects them individually, as well as the whole institution of the military. And what employer, wouldn't, love to kind of operate within a world where they can't be sued, where there's no accountability? And I'm not kind of calling out like the morals of our leadership there in the Pentagon, but it's just from a corporate level, they fight a tooth and nail to save Feres and to protect Feres. And so when, I testified on this back in 2019, it's where I had the consensus of the committee that was in the House on some military personnel. It's where I had a consensus there. But then what happened is the Pentagon kind of moved in the background and so basically said that they went to the members and said, look, if you attempt to roll back the Feres Doctrine, you'll be painted as being so soft on defense. And that's what they do. It's where the kind of assumption is, if you allow there to be civil suits, it's where you're seen as being pro the plaintiff's bar, pro litigation, and being kind of soft on defense, and where the Pentagon then will get in the way of your reelection, and that's what will happen there. And I saw it, and so what happened is, once that kind of rollout occurred, it's where the viewpoints of the members so changed, and by members, I mean the House members.
It's really really disappointing that it comes down to that kind of politics, but I think we can all understand that it does. Congress could fix this. It'd be a simple fix, but it's unlikely. I think actually the court pulling Feres back and saying that it was not the original intent to protect those who are committing rape. That's clearly unrelated to service members' military duties, is where this will ultimately go. Are you hopeful that will occur, Dwight?
Well, Jim, and just it's where when I went to testify in 19, it's where the context was some medical malpractice. I was a part of a bill. I was the expert on a bill that would have allowed a service member to bring a civil lawsuit if their doctor made a mistake in terms of the care that was given. There are all kind of errors that happen in the medical, within the medical scope in terms of just your day-to-day, like a pregnancy where there's a hysterectomy where the doctor makes a mistake, or there's a dentist, right? It's where there are dentists who give too much of the Novocaine,
sure.
And the person will go into a coma. There's all kind of errors that happen there. And we had victim after victim who testified to the errors that were made. And if these things happen to, if they happen to me or you when we are civilians, if they happen to the audience, and if there are civilians and they're harmed by their doctor through the error of some negligence, it's where they can sue. And doctors are well aware of this. And doctors, it's been well established. It's where they it's where they give better care and are more so if they know that they could be held to account in a court of law. But some military doctors, they don't have this kind of accountability. They can't be sued they can't be sued for malpractice.
Yeah, their negligence is protected.
And so as a result, it's where there's more recklessness there. And so that was the context of my testimony. And what happened was, again, it's where we had the support of the committee, but then after the fact, it's where they all flipped on us.
Well, I would hope that the sexual assault harassment area is different and viewed differently, and maybe Congress would do something, but maybe it won't. But again, I'm back to hopefully the courts will do this. Other circuits will follow what the Ninth Circuit has said, and ultimately it's got to be resolved by the U.S. Supreme Court. So I hope veteran radio listeners didn't find this, this is a little wonky, because it really impacts every service member's life. And there's way too much sexual discrimination and harassment and assault going on in the military, and maybe bringing the element of civil liability to somebody would correct that kind of behavior. Dwight Stirling, I really appreciate the extra time you've spent with us today to talk about this issue, and encourage you, as I'm sure I don't have to continue your fight to deal with the vestiges of the Feres Doctrine.
Yeah, good, Jim. Hey, thank you very much. It was a pleasure.
And I want to thank everybody for listening to Veterans Radio today. I am Jim Fausone. It's been a pleasure to be your host. I'm a veterans disability lawyer at Legal Help for Veterans, and you can reach us at 800-693-4800 or legalhelpforveterans.com on the web. You can follow Veterans Radio on Facebook and listen to its podcasts and internet radio shows
by visiting us at veteransradio.org. That's veteransradio.org.
And until next time, You are dismissed.
If you have a VA claim denied by the Board of Veterans' Appeals, contact Legal Help for Veterans at 1-800-693-4800. They're experts in handling cases before the U.S. Court of Appeals for Veterans Claims. Their number again, 1-800-693-4800.
We again want to thank our national sponsors, the National Veterans Business Development Council, nvbdc.org, VA Ann Arbor Health Care System, the Vietnam Veterans of America Charles S. Kettles Chapter, Ann Arbor, Michigan, VFW Graf O'Hara Post 423 in Ann Arbor, and the American Legion Press Corn Post 46, also in Ann Arbor. We appreciate all your support. You can go to veteransradio.net, click on the sponsor level, and continue to support keeping Veterans Radio on the air. And until next time, you are dismissed.
It is Ryan here, and I have a question for you. What do you do when you win? Like, are you a fist pumper, a woo-hooer, a hand clapper, a high fiver? I kind of like the high five, but if you want to hone in on those winning moves, check out Chumba Casino. At ChumbaCasino.com, choose from hundreds of social casino-style games for your chance to redeem serious cash prizes. There are new game releases weekly, plus free daily bonuses, so don't wait. Start having the most fun ever at ChumbaCasino.com.
No purchase necessary. VGW Group. Void where prohibited by law. See terms and conditions. 18+.